Welcome everyone to the last webinar in our ZOOOM Toolkit webinar series, where we're introducing the ZOOOM Toolkit to various categories of stakeholders. So today's talk is aimed at intellectual property officers and not really open source lawyers and consultants, although they might be interested as well in joining and learning more about what we offer with the ZOOOM Toolkit. So just a very brief introduction to the toolkit, so you can get an idea of why this exists and in what context it was created. And then I'm going to show you in a few minutes. We'll go through the actual toolkit too, so you can get an idea of what tools there are available specifically for intellectual property officers, but not only. The idea is really on using the tools and how you can put them into practice. So the ZOOOM Toolkit was born out of a project, European Union project called ZOOOM, which aims to bridge essentially business models operating on the basis of open source technologies with corresponding licensing models, which are, let's say, open source friendly. So the assumption is that most companies would not opt for solely open source IP strategy. And this, of course, makes sense because in today's world, at the very least, you also need to protect your brand, which means you're going to obtain proprietary rights over your over the trademark, for instance. Or if you're in the hardware business, chances are that you are sooner rather than later, you're gonna have to navigate patent portfolios, whether yours or a third party's portfolio. So in this sense, the assumption is that companies might decide to which degree they would like to stay open and which assets they should release as open source. We generally in our work, we advise that companies follow the 80-20 rule. So essentially this rule stands for the following idea that 80%, the 20% of the asset actually support the remaining 80%, and 20% of the assets of a company are where the true IP value lies. So when indeed for this 20%, you might want to seek patents or obtain any other form of exclusivity through intellectual property rights. Whereas the remaining 80% is IP of the supporting varieties, we call it. So that means that this is IP that's not so valuable in and of itself. It's important to support the remaining 20%. But for these 80%, you could actually adopt an open source strategy, and you might want to sort of release on a friendly, whether permissive or copyleft licensing terms to a community, or even create communities around this supporting variety of IP. So that's the main idea of our approach. We're by no means purists, but we want to support actual businesses that can remain sustainable over longer periods of time. So the toolkit is based on a framework that we created in ZOOOM. It's the so-called ZOOOM licensing framework, where we adopt a methodology from social sciences, the so-called structure, conduct, and performance, SCP. So we apply this to our context of companies operating in the open source field, so open source software, open hardware, and open data. And in terms of structure, we study and we are interested in figuring out the age, size, and types of the companies, whether they have any experience with open source technologies, the level of business readiness, as well as whether they have any experience with any of the emerging technologies that we focus on in this project, such as blockchain, artificial intelligence, quantum computation, or robotics. In terms of conduct, we study three main aspects of the business, legal, and social conduct of a company. In terms of business conduct, we're interested in where the company stands within its ecosystem. What is the role of openness in the company so far? To what extent they appreciate or would like to embed open source technologies into their business model, and how to do that. In terms of legal conduct, we study and we analyze the IP strategies and just what I was explaining, the complementarities between open source and proprietary intellectual property. We also deal with the inbound and outbound licensing approaches of companies, such as, for instance, when you consume open source, you need to make sure that at the horizontal level, all of the elements, all of the components that you use, for instance, to build a software project, have licenses that are horizontally compatible with each other. There is no license which prohibits combination of a particular piece of code, for example, with another piece of code. Then for the same goes for the outbound licensing. So you need to make sure that whatever license, open source license you decide to release on, it must meet the most stringent conditions of either of the input licenses. So you can't release on more favorable licenses than you have in your input code base. And then also we provide a tool that aims to guide companies in navigating the complexities of artificial intelligence as a hybrid asset, intellectual property asset. So we provide a scale which shows how different components of AI might sit differently on this scale in terms of what sorts of intellectual property rights you might obtain over them, and decide, again, make decisions, strategic decisions over what to release on an open source licensing condition and what not. And then in terms of social conduct of companies, we're interested in the social impact of using open source technologies, as well as the ethical considerations, the ethos that drives companies in choosing open source and choosing to release open source as opposed to proprietary. And then finally, in terms of performance, we're interested in mostly sustainability in terms of performance from the perspective of economic sustainability, legal and social sustainability. So this is the toolkit as it stands today. It's still pretty much in pre-release state, but we are finalizing mostly in terms of user experience, improving the user experience and making sure that we make the tools as easy to use as possible and as accessible as possible to a wide variety of audiences. Now, since today's talk is focused on intellectual property officers, I will probably not go through the entire scope of the toolkit, but just for the sake of completeness, I'm just going to mention briefly all of the elements so that you can get an idea of what's in store for you. So the first component is the so-called open asset strategy, where we aim to guide organizations into how to define an open source friendly policy strategy to basically align this strategy with their business model. So the rule of thumb that we adopt in Zoom is that businesses, and accordingly their advisors, and you, for instance, as IP officers, should really consider the business models first. So you need to make sure that you understand the business model of a company. So only then you can select an appropriate licensing model, and not vice versa. Just because you love open source does not mean that any solution can be released under an open source license, because it might turn out that 3 or 5 years down the line, you no longer find it sustainable to run your business under such open source licensing conditions. So if there is a fundamental misalignment between the business and the licensing model, it might be extremely detrimental to your business. And we have had such examples of companies willing to switch from an open source to various types of fair source, as are now called, models, where essentially you have the source code available, but it is only available for use under certain conditions, such as, for example, non-commercial use, or if you're a cloud computing service provider, you might need to obtain a specific license and actually pay for it, which is of course incompatible with the fundamental principles of the open source definition. So we provide these types of tools in this category. We also have a library of cases where we explore some inspiring business cases within the open source software, open hardware, and open data domains and the ecosystem. So some examples of companies who have made it. based partly or wholly on open source technologies. We also have the training program, which is a set of materials, including videos, presentation slides, as well as some additional external resources by trusted providers such as the Linux Foundation, for example. They have a lovely collection of training materials that most of you would probably be interested in learning more. So we have referenced these in various modules of the training materials. And finally, the AI as a hybrid asset, like I mentioned, this is essentially a reasoning tool for you to make sense of which elements of an AI system are protected, could be protected under which intellectual property or non-intellectual property regimes. So in terms of open access strategy, the tools that we offer are grouped in various categories. So we have the licensing tools, which support organizations in choosing the most appropriate license to their business model. We have the business tools, which help you reason about the most appropriate business model for what you want to do. But it's going to be open core or another type of an open source model. We sort of try and through a set of questions nudge you into the right direction. The business profiles already mentioned, which are typified essentially scenarios for companies operating in various domains such as manufacturing or agriculture to help them structure a business around it using open source technologies. We also have tools for supporting organizations which are mostly orientated towards the setting up of an open source programs office. And we have our glossary and a list of frequently asked questions. The library of cases I already discussed, which is a set of collection of interviews and business profiles of companies, where you can get an idea of how exactly they leverage open source technologies and how this makes their business model successful. Training materials we already discussed, and the AI as a hybrid asset tool. So for each of these categories, you will find that they are basically categorized in three main categories. So we have open source software, open data, and open hardware. Now, some of the tools quite obviously would overlap across these three different categories, but that's not necessarily the case. We have some specific tools for some of the categories. So for instance, we have license selection tools for open source software and open data. Unfortunately, for hardware, we don't have anything like that, mostly because the open hardware space still remain largely experimental. I would say, even though a lot of work has been going on, especially with initiatives like RISC-V and companies being built on this open instruction set architecture, still the industry is moving at a slower pace. So there has not been that much and that extensive discussion when it comes to open hardware licensing. And indeed, if I were to mention the most dominant prevalent license in this space, it would most probably be the Solderbart 2 license created by fellow attorney Andrew Katz. And of course, the open hardware license, which originated at CERN, but since it is a copyleft license, industrial players tend to avoid it. We also have the business tools, and I would really like to highlight the business model innovation map, which for you as IP officers should probably be useful when companies approach you with requests for advice on how to structure their company or how to create, for instance, a spin-off, and whether an open source licensing strategy would be appropriate for them. This innovation map actually aims to support these companies in figuring out the best business model for what they want to do. Now, obviously, these can't be as detailed as a company would like to, and that's where the role of an IP officer or a consultant kicks in, because you then can really tailor your advice to their specific needs. Basically the business profiles we already discussed. You can see some examples here, such as startups working in the field of agriculture, or medium-sized company which aims to become an enabler in open data ecosystems. Again, you should think of these as reasoning tools which should help you or your customers, your stakeholders, reason about the business models that are most appropriate to them, one, and secondly, address some critical questions. So in each of these profiles, you will find set of questions concerning risk, concerning opportunities that you need to ask prior to making an informed decision. Same for supporting organization too. So we have the service portfolio analysis, which basically analyzes at the more granular level the various services provided by an open source programs office. This can be used to either structure such service as part of your institution. If you're an IP officer, for instance, working for a public institution such as a patent office or a copyright office, or it could be used by private stakeholders who want to build a service portfolio as part of their own consulting business. For instance, if you're a lawyer or a technologist advising companies, you might want to pick and choose some of these various services and provide them on an on-demand basis. So this is really configurable and can be adapted to the needs of to your specific needs. The glossary terms, it's quite self-explanatory. So we have created a list of important terms, notions, concepts, including our own definitions of concepts such as business ecosystem or business model. The idea is really to facilitate a basic understanding of some of the most commonly met terms, such as what is the PST, what does the AGPLv3 stand for. The idea is to support you in or your clients or your customers in getting to know the language of open source. Same goes for frequently asked questions, where we have defined both a set of basic questions such as what is open source or how can firms leverage open data ecosystems, to questions such as how can, for example, open data generate revenue, or how can we make money using open hardware? So really practice-oriented questions. And then the library of cases, you can see we have categorized these on the basis of technologies, but also on the basis of domains of activity, such as, for example, in the legal domain or in or organizational support, technical or specific technologies such as, for instance, artificial intelligence. And then the training modules, so they range from very basic modules across three categories, so technological, business, and legal, to more advanced modules where we discuss the nitty-gritty of, for instance, open source licensing or how to maintain an open source community. And then the AI is a hybrid asset tool, which is a walkthrough of the components of AI and how they relate to various modes of IP protection. You will see this scale here. And as you go through the tool, it will guide you into figuring out whether, for example, what you have might be protected under the EU database rights, or whether it's protected by copyright, whether it's protected as data through, for example, contractual stipulations, or whether it's not protected at all, because there are also elements in AI that don't squarely fit into any of the existing IP categories. And then for these sort of assets, you might need to figure out an alternative strategy for protection, if they're worthy of protection indeed. So this is the contact information of some of the team members, and now I would like to jump straight to our demonstration session, where I'm going to show you what the toolkit actually looks like and how it works. So what you are seeing now is the landing page of the Zoom project, but if you were to click on the ZOOM Toolkit button in the upper right corner, it would take you to the landing page of the toolkit. So there are two entry points into the toolkit. So one is to simply click on Get Started, which will take you to the main page of the toolkit, or you could access directly any of the main categories we have highlighted here, like the open asset strategy, the library of cases, training material, or AI as a hybrid asset. So let's assume you want to just find out more about Zoom. If you click on Open Asset Strategy, this will take you to the various tools, such as the licensing or compliance tools, or the supporting organization tools. Now, I would imagine that for you as IP officers, what would be most useful would be probably the licensing and business tools. So if we go to licensing tools, for example, You would see here that we have tools such as collection of compliance tools. These are technical tools that are offered as a Docker image that developers might want to use and integrate into their development workflows. Or you might also access our own Zoom licensing decision tree. So let's try this out. And it will take you to a set of questions that you need to ask. So this tool aims to support you in selecting a most appropriate license for a component of your software. So perhaps not the full package, but rather you might want to license a particular library or another software component and a particular license. You're not quite sure what would make sense to you. So the aim of this tool is to support you in making an informed choice. So the first question that we ask is whether you want to restrict the use of the software in any way. Because, for instance, if you want to restrict the software to non-commercial uses or to limit its use in cloud services, then you would, as I said, it would clearly be in contradiction with the fundamental principles of non-discrimination and prohibition of field of use, which are principles of the open source definition. So if we say, yes, I want to restrict the use of the software, then you would get a straightforward answer, which is open source, at least for this component of your product, is not an option. But let's assume we actually don't want to restrict the use of the software, which would take us to the second question, namely whether we seek maximum adoption. So by maximum adoption, we mean whether you want to basically enable anyone in the community to use your software for whatever purpose they want, and as freely as possible, meaning at best they would have to provide attribution that you were the creator of this software, and they would have to acknowledge and reproduce the license text, but nothing more than that. This is the category of license that we call permissive licenses, because you don't actually have, for example, to share your modifications to this piece of code that you've used. So there are no obligations of sharing of modifications, essentially, with this family of licenses. Whereas for copyleft licenses, for example, you would also have to share your modifications together with the original code. So if we say that we want maximum adoption, for example, which would imply we are aiming for a permissive license, then we get a specific question whether we would like to get attribution when people use our software, which in most cases would be the case. People would like to be acknowledged for the work they've done, and to also keep track of whether and where their work is being used. So let's say that we would like to get attribution. And then we have a fourth question, whether you would like to grant express patent license or not. This will very much depend on whether your customer, for example, has a patent portfolio or not, and whether they would like to sort of take the risks of granting a license to inventions they might have patents over and that might be implemented in software. So this is a strategic choice, which you should also always discuss, of course, with your patent attorney or at least an IP officer that like yourselves, who can actually advise companies on what would make sense. But let's say that we are cautious. We would not like to really grant express patent licenses to err on the safe side. So in this case, you would get a follow-up questions, which is whether you would like your license to be compatible with GPL v2. There are good reasons for you to pursue this sort of compatibility. But let's say that in our case, we don't actually care about that. So we say, no, I would not like it to be compatible with the GPL v2. And there we go. We have a recommendation of a license, which is in our case Apache 2.0. So if you click upon this link, it will take you to an explanation note as to what the Apache 2.0 stands for and why it might serve you. So this is the one of the tools. You might also be interested to take a look as an IP officer at our business innovation map, which is available both. So this is my colleague Yuta Suksi, who has recorded a video introducing the business model innovation map. So there are two ways to access this tool. Where there's a downloadable version that you can print on an A3 format paper, for example, and use as a tool during an internal workshop or a workshop with your stakeholders if you're an IP officer. Or you might also use it independently as an interactive map online, where again, much like the licensing tools, you actually need to explain and to answer certain questions, such as to specify your business objectives, to identify the value proposition, and then view and filter some results. So let's say I want to generate business focusing on my own asset using software, hardware, or data. And then I want to focus on value creation opportunities which are embedded in open source software, hardware, data as an asset. So we're focusing on actually monetizing the assets as opposed to services related to that asset. And then we get this table with some recommendations. So for example, the open core model using update subscriptions, or proprietary with free and open source software extensions, or delayed release of free and open source software, or dual licensing. So you have a variety of options. Obviously, this will not be the case for just about any choice, but in this case, we have plenty of options to choose from. And you have examples of some pieces of software companies who have successfully utilized the respective model. So I will not go into any of the other tools because we have a variety of tools. Like I said, I would very warmly invite you to explore at your leisure. And then, of course, if you have any questions or would like to chat with us or provide feedback maybe on how the toolkit might be improved, please feel free to reach out. This toolkit is currently licensed under Creative Commons Attribution Share Alike 4.0, and it's going to be released for community development at the end of this project. Will be uploaded to a public code sharing repository, which means that you and anyone else would be able to contribute and develop this further or tailor to your own needs. So thank you very much for your time, and I'm going to stop the recording in case there are any questions. Thank you. So one of our members of the audience actually asked a follow-up question to this webinar, which I think the answer to which is important for all the stakeholders in the Zoom community. What is the main difference between open hardware and other sorts of assets, particularly software? In fact, that's what makes open hardware licensing and open hardware business models much more challenging compared to any other category of open source assets. The problem is that in software, you're operating with bits, whereas with hardware, you're really manipulating atoms in the real space. This is a lovely explanation that fellow attorney Andrew Katz provides when he talks about open hardware, and I very much share his view that open hardware is so complicated because we're actually manufacturing things in the real world. We actually, and this of course could take enormous resources. Like you need access to manufacturing facilities. You need electronic components to build designs. So it's not so easy to first of all to implement the design, and secondly to control its distribution. Because how do we control the distribution of physical assets in intellectual property? We really do this by means of patent rights. So when you obtain a patent over an invention, anybody who practices your invention, whether in software or otherwise, could actually potentially be infringing on your patent rights, which means that you need a way to enforce them. And the 20-year monopoly granted by patent rights provides you with that opportunity to enforce your rights, regardless of how your idea, the technical teaching of your invention has been implemented. Quite clearly, we don't have anything like that when it comes, for instance, with design rights, with copyrights, or the protection is not so stringent. And in this case, it becomes quite challenging to control the distribution of the physical items manufactured on the basis of an open hardware design. So that's why once you release an open hardware design, your main concern will be that virtually anyone could take it, provided they have access to a 3D printer or more complicated manufacturing facilities. And there's hardly anything that can stop them from manufacturing and using this product. And none of the open hardware licenses actually give you any sort of protection, mostly because the underlying rights that these licenses deal with are whether design rights or copyright, but never really patent rights as such, because if you were to obtain a patent, you would most likely not be in the open hardware business, or at least you would not be releasing your main product under an open hardware license. So I think this is a main issue, and of course, like in open source software, when people ask what why would people go about open source, why would they release their product under an open source license? The answer is usually, well, not because of the product itself. I mean, you obviously want to create a community around it. You want to share your code with this product. Rather, you aim to provide a quality assurance with the product. And that's how most of the successful open source software business models today operate. They operate on the basis of auxiliary services related to the product. So you provide maintenance, or you provide quality assurance, or you provide vetting of certain packages, or overall maintenance. It's really the business model of Red Hat. So the distribution that is at the foundation of Red Hat Enterprise Linux, it's Fedora Linux, and Fedora is a free and open source distribution, freely available. You don't have to pay Red Hat anything to use it. And Fedora is used as a test bed for Red Hat Enterprise Linux, which comes with the support, maintenance, and of course, contractual warranties, which is not something that should be underestimated in an enterprise context, because once, for example, if there's an issue with your operating system, or you're out of business for a couple of days because of a faulty patch, you then have a contractual relationship with a provider of this quality assurance for this software, and then you can potentially enforce your contractual rights. So this is the main difference. We don't have, similar models are emerging slowly around open hardware. So I don't think that, again, the value will be in the hardware as such, but rather in the related services that you provide around it. But thanks a lot for your question, because that's a very common misunderstanding, and it boils down to the way hardware and software are protected by different rights of intellectual property. Okay, I don't see any other questions. So with this, I would like to thank you all very much for joining this webinar. The recording will be made available online, and I look forward to seeing you soon in one of our other Zoom activities. Thank you, and have a great day.